Welcome everyone to Foley and Lardner's webinar on the new tax-exempt bond management contract safe harbors revenue procedure 2016-44. I'm Mike Bailey with the Chicago office of Foley and Lardner. I'm pleased to be joined by Dana Locke, my colleague from our Milwaukee office, and Mark Sheedley, my colleague from our San Francisco office. We all practice in public finance, healthcare finance, and tax. We're going to thank you all for joining us. In the next hour, we're going to describe the new revenue procedure, discuss its opportunities and also its pitfalls, and discuss how to respond to this important new development. Today's program will run 1 hour, and we will apply for one general CLE credit. Anyone wishing to receive credit for today's program must enter the code when announced. A box to enter the code will appear on your screen for approximately 30 seconds. Everyone seeking CLE credit must enter the code in the box on their screen at that time. All New York, New Jersey, and Kansas attendees applying for CLE credit must also fill out an attorney affirmation form and write down the course code. The attorney affirmation form and a copy of today's slides can be obtained in the resource widget list at the bottom of your screen. For New York attorneys, those of you with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be emailed to Christina Wade, cwade@foley.com. CLE certificates will be sent to eligible attendees via email in approximately 8 weeks. Questions can be submitted during the term of the web conference by entering them in the Q&A widget, which is open on the left side of your screen. We will answer questions at the end as time permits. As I mentioned, this is a very important new development in public finance and healthcare finance. And I'd like to just take a minute to explain why this new guidance is important. Next slide, please. The guidance applies technically to all governmental bonds and qualified 501c3 bonds. So it applies to a wide variety of different types of bonds that are subject to the public use requirements. In general, as you know, 5% or 10% limits apply to private business use under these rules. Management contract is the term used for virtually all service contracts, not just contracts that you might think of as being management contracts, but any contracts under which a service provider provides service. The tax rules provide that a bond issue isn't necessarily bad if it has more than the permitted amount of private business use, but avoiding private use contracts is often easier than monitoring and measuring private business use. And for certain types of bonds, analysis of whether a management contract results in private use is often the most important and time-consuming tax question. For example, if you have a utility system that has a single management contract, if the management contract results in private business use, it may be that all of the bonds of the utility system are non-compliant. Also, in the case of hospital bonds, hospitals conventionally enter into many service contracts with physicians and others, and the procedures used to make sure that those service contracts are compliant is an important and time-consuming task. Just to provide an overview of the new revenue procedure, it sets forth a different framework than the existing guidance, which is Revenue Procedure 9713 as amended. The new guidance is in many ways much more flexible than 9713, but in other ways much more restrictive. And in general, the new guidance is favorable for longer-term management contracts, such as contracts for infrastructure, but could be more burdensome for certain types of shorter-term contracts. And one of the issues presented by the new guidance is that there's basically a one-size-fits-all approach. So the same rules apply, the same safe harbor rules apply regardless of whether you have a 2-year contract or 30-year contract. And that creates some practical problems that we're going to discuss. The effective dates are particularly important. These new safe harbors can be used immediately. There is a transition period. The safe harbors and Revenue Procedure 9713 as amended can be relied upon for contracts entered into before August 18th, 2017 and not materially modified after that date. The special transition rule also provides for grandfathering for contracts extended pursuant to an option in the contract even if extended after that date. And the original end date for transition relief was February 18th, 2017. After the IRS released this revenue procedure, they extended the transition period another 6 months, so basically we have a year to respond to it. And I think that reflects an IRS acknowledgement that the new safe harbors could result in some tax compliance problems. That is, even though it's generally favorable for many types of contracts, it does create some unexpected issues and problems. I thought I'd give just a brief overview of the history of this management contract safe harbor guidance. The IRS has long taken the view that service contracts with respect to bond finance property can result in private business use of that property. And indeed, there were some safe harbors that the IRS established in revenue procedures going back to the early 80s. The major legislation in the tax-exempt bond area was the tax-exempt reform, with the Tax Reform Act of 1986. That law described in some detail what types of contracts and other arrangements result in private business use, and they specifically listed arrangements like ownership, leases, output contracts, but also service contracts. And indeed, there was a somewhat more complete discussion of service contracts than other types of contracts in the 86 Act. And in particular, there was a statutory direction from Congress to create, for the IRS to create a new safe harbor for service contracts, and that's the so-called 1301E of the Tax Reform Act of 86. And it directed the Treasury to establish a safe harbor for 5-year contracts having 50% fixed fee compensation that could be terminable without cause in 3 years. So there were major private business use regulations published in 97, and Revenue Procedure 9713 was published at the same time. I was at the IRS Office of Chief Counsel. I was one of the authors of those regulations and the revenue procedure. And basically, the approach we took in framing the safe harbor was saying, well, Congress directed us to create a safe harbor based on the term and the type of compensation arrangement. If you have a 50% safe harbor for 5 years, we'll extrapolate them from that. We'll have an 80% safe harbor for 10 years, 95% for 15 years, and for shorter contracts, 3 years and 2-year contracts, you can have various types of variable compensation. So the whole structure of 9713 wasn't just entirely made up. It was really responsive to a statutory direction from Congress. In 2014, as many of you know, there was a significant development for contracts having a term not greater than 5 years. The service said, well, basically, you don't have to worry about the type of compensation arrangement, provided that it can be fixed or variable. It doesn't have to be 50% fixed. It doesn't have to be a particular type of compensation arrangement. But generally, it can't be based on a share of, the compensation can't be based on a share of net profits. So that's where 9713 came from. I just want to highlight that we're talking about safe harbors. This isn't a change to the regulations or what the substantive regulations say about what results in private business use. It's intended to provide protections to issuers and borrowers that really shouldn't properly be used by IRS agents as a standard for what is private business use. Even though they may do so, we don't know. The rules and the regulations have priority over these safe harbors, so we need to consider this new guidance in the context of the regulations, which have not changed, and the substantive standards in the regulations haven't changed. Just the IRS's safe harbor interpretations of those regulations have changed. Contracts not meeting all of these new requirements could still reasonably be determined not to result in private business use. So what do the regulations say? Well, the regulations, the most important thing the regulations say about service contracts is that a management contract generally results in private business use if the contract provides for compensation for services based in whole or in part on a share of net profits from the operation of the facility. Then the regulations create certain exceptions for certain types of service contracts, like contracts that are solely incidental, or the contracts where the only compensation to the service provider is reimbursement of actual and direct expenses. The regulations say that if you have something that's a management contract or service contract in form, but in substance, if it's a lease or transfers ownership to the service provider, then it's bad use. Otherwise, only a vague facts and circumstances test apply. And again, this new revenue procedure does not change the rules and the regulations. So this new revenue procedure is much more sort of principles-based. That's the way the revenue procedure describes itself. And it says that Revenue Procedure 9713 is superseded. That means literally after this transition period, it won't exist anymore. And all of the safe harbors based on term and fixed fee are basically superseded. It's much more liberal to the extent that up to a 30-year term is permitted. The rule is retained that the contract have a term not more than 80% of the reasonably expected life of the managed property. And there's new requirements relating to control, no bearing of risk of losses, risk of loss, and no inconsistent tax position. And I'll just say that generally speaking, this new principles-based approach has somewhat fewer bright lines than the old approach, and it's really somewhat more based on general federal income tax rules for what a service contract is compared to a lease or a partnership arrangement or arrangement that transfers ownership. So it's much more sort of grounded in general federal income tax rules and case law than the old Revenue Procedure 9713 standards. Technically, the Revenue Procedure sets forth two new safe harbors. The main one is this new safe harbor for a 30-year principles-based safe harbor with all the factors we're going to be discussing. There's actually a second safe harbor for so-called eligible expense reimbursement arrangements, which we're also going to discuss, but spend less time discussing. Now, Mark is going to lead the discussion of shorter-term contracts.
So, shall I pick up here, Mike?
Yes, why don't you pick up here, Mark?
Okay. Let's advance the slide here. So, the first factor that I want to talk about is the net profit limitation. That is, no element of the compensation of a service provider can be based on the net profits from the enterprise. And certainly this factor is not at all surprising in the sense that having a net profits interest in an enterprise is sort of a basic or elemental attribute of having a proprietary or partnership type interest in the enterprise, and therefore is an indication of private business use. As Mike mentioned, this is the net profit factor is the one thing that the regulations talk about, in the sense that a compensation arrangement generally results in private business use if that compensation is based in whole or in part on the net profits of the managed enterprise. Similarly, the old RevProc 9713 had a net profits limitation. But in this new manifestation of 2016-44, the rule may be a little bit broader than it historically has been. And looking at the slide here, compensation to the service provider will not be treated as providing a share of net profits if no element, and emphasis on the word no element, of the compensation takes into account or is contingent upon net profits or both revenue and expense in some combination. Again, the key term here is elements of compensation, and they are specifically defined as eligibility for, the amount of, and the timing of payment for compensation. In the months leading up to the promulgation of this new RevProc, there were a number of signals from the IRS that they were loosening the standards for management contracts. One of those signals was a private letter ruling released in 2016, in which an element of incentive compensation was contingent upon the managed enterprise achieving a certain level of profitability. And in the private letter ruling, the IRS said, well, that should be okay, because the amount of this element of incentive compensation is not based on net profits, just really realization of a certain level of net profit is a trigger point, a requirement for the payment of it. With this safe harbor, it seems clear that that type of arrangement would not qualify for safe harbor protection, because again, its eligibility for or the timing of the payment is based on net profits. Now, the IRS has indicated that they're not withdrawing from the position stated in that private letter ruling, but it's clear that that type of arrangement would not qualify for safe harbor protection, because the trigger point, again, is a net profit element.
Right, Mark. And just to elaborate a little bit, after this revenue procedure came out, I called up the author at the IRS Office of Chief Counsel of that private letter ruling, and I said, well, you just issued this private letter ruling that said under particular facts and circumstances, you could have additional payments to the service provider triggered by a factor that really was in substance a profitability or net profits factor. And there were particular facts and circumstances under that ruling. The actual payment was not based on a share of the net profit. The actual payment was a percentage of gross revenues. And so the actual amount of the payment was not itself, the amount was not based on net profits. But the fact that they were getting the payment was made on net profits, and then there were a variety of other factors. I said, well, literally under this revenue procedure, that private letter ruling you just issued would not be protected. And the response was, that's true, but I think that private letter ruling holdings still should apply, and we're not revoking that private letter ruling. But I understand your problem. When you look at this revenue procedure, it's not literally protected by the safe harbor. So we're going to have a number of these types of questions of when are arrangements that are slightly outside the safe harbor still going to be okay? And if the IRS says, well, that letter ruling is okay, and in that circumstance we accepted a compensation arrangement that had a net profits trigger, when are we going to know what types of net profit triggers are acceptable? And that's something that I think we just will need to be working through, carefully understanding statements of IRS and Treasury officials over the next year. There may be additional private letter rulings, but it's one example of how we're going to have to be thinking of instances where we may have to get comfortable with arrangements that aren't necessarily exactly within all of the requirements of these safe harbors. So please, Mark, go ahead.
Well, thank you, Mike. I think let's turn the program over to Dana now to talk about the control element.
Well, why don't I jump in, and Dana can jump in when she's available. As I think I mentioned, there are a number of new requirements that are in this revenue procedure, and many of them have to do with really substantive law for what is the difference between a service contract and another type of arrangement, such a lease. And the basic idea is the service provider is sort of like the agent of the issuer or borrower, and they're under the control of the issuer and borrower. So this factor is now listed in some detail in this new revenue procedure, and it says to be within the safe harbor, the qualified user must exercise a significant degree of control over use of the managed property. And this control requirement is met if the contract requires that the qualified user approve the annual budget of the financed property, capital expenditures with respect to the financed property, each disposition of the property that's part of the managed property, rates charged for the use of the managed property, and the general nature and type of use of the managed property. And these 5 listed control factors appear to be requirements. That is, they're not safe harbors within a safe harbor. That is, there's been some discussion in the industry that the real standard is just generally the qualified user, which is the issuer or borrower, generally has to exercise a significant degree of control, and that can be reflected in any number of ways, and these 5 factors are just examples. Based on my discussions with Treasury officials, they say to be within the safe harbor, you have to have all of these, although the whole thing is just a safe harbor. And then the revenue procedure sets forth a further explanation of the 5 factors that apparently is intended to somewhat soften the strictness of the control requirement. It says the qualified user may show approval of capital expenditures by approving an annual budget for capital expenditures, describe a functional purpose and maximum amounts. That is, they might not have to approve each and every specific capital expenditure. The qualified user may show approval of dispositions of property in a similar manner. Again, by talking about amounts and types of dispositions, presumably would be okay. And I think most importantly, it says a qualified user may show approval of rates by either expressly approving such rates or the methodology for setting such rates, or by including in the contract a requirement that the service provider charge rates that are reasonable and customary as specifically determined by an independent third party. And this provision relating to control of rates may create particular problems for short-term contracts. This is likely the new requirement that will raise most questions under the new safe harbor. As I mentioned, many shorter-term contracts customarily treated as meeting the Revenue 9713 safe harbor do not appear to meet all of the factors in this requirement. For example, the approval of rates, and one of the primary examples is in the case of hospital financing, the physician contracts within a bond-financed hospital facility. The physicians may have separate billing arrangements, and The hospital may in some cases control the rates charged by the physicians, but in other cases they'll just say the rates are reasonable and customary, or they'll say that the hospital doesn't control the rates. And literally, under this safe harbor, those contracts which have traditionally treated widely in the industry as being within the safe harbor won't necessarily be in the safe harbor anymore. And I would describe this as being a problem that we have now a one-size-fits-all approach, regardless of whether you have a 2-year contract or a 30-year contract. And the basic mindset of the IRS in drafting this revenue procedure was to create a lot more flexibility, particularly for long-term infrastructure contracts. So you can see if you have a long-term contract for a water facility or a sewer facility, one of the factors that could justify having such a long-term contract is that the issuer has a lot of control over the operations of the finance property, the operations of the system. It should be less important to have so much control for a 2-year contract, but there's nothing in this revenue procedure that sort of scales the approach depending on whether it's a very long-term arrangement or a short-term arrangement. So at least for now, we're going to be left with some difficult questions for these particularly shorter-term contracts. What is a methodology for setting rates that will qualify? That's not answered. What types of entities will qualify as independent third parties to approve rates that are reasonable and customary? Presumably, a contract that just says the rates that are reasonable and customary won't, strictly speaking, qualify for the safe harbor. And I will say that this is a little bit different than the net profits standard, because we've been living with the net profit standard basically since '97. But these new requirements relating to control haven't been interpreted previously under these revenue procedures. We have no guidance for what a methodology for setting rates is. Now, maybe over the next year we'll get some further guidance from the service. Maybe they'll be very flexible in what we can regard as a methodology for setting rates, but that's going to be an important question. So, our view is that there may be standards developed for positions for contracts that not necessarily meet all of the control factors if other facts and circumstances are present. And it may be that some in the industry will get comfortable with not meeting all of these control factors for very short-term contracts, but that remains to be seen, and we'll have to very carefully monitor what the IRS and Treasury say about that. Mark, you were going to pick up on no bearing of risk of loss?
I would love to, Mike. So when I was speaking before, we were talking about net profits, that compensation can't be based on net profits. There's a reciprocal rule that a service provider cannot bear the risk of net losses of the managed property. As discussed with the for-profit or with the profit element, and that it was fairly broadly based in terms of the looking at all elements of compensation, including eligibility, amount, and timing. A similar kind of approach is taken in terms of the net loss factor. In that an arrangement will not be treated as requiring the service provider to bear a share of net loss if the determination of the amount of compensation and the amount of any expense do not take into account the managed property's net losses, and the timing of the payment is not contingent upon the managed property's net losses. So a similar sort of broad-based approach is taken with this factor in terms of a service provider not being subject to risk of net losses. In my own thinking, it seems to me these are pretty similar factors, and I've always kind of wondered why they weren't combined into a single factor, but for whatever reason, and and although the IRS takes a similar approach with the net loss limitation, they do so with different language, even though it seems that the result, the overall approach, is pretty comparable. It is helpful, however, that the revenue procedure goes on to provide what would be permitted, and that is a service provider whose compensation is reduced by a stated dollar amount for failure to keep expenses within certain targeted areas will not be treated as a share of net losses. So that is helpful. Again, being dinged for not keeping expenses under control is not a net loss limitation in the sense that it looks only at expense and not any combination of revenue and expense. Nonetheless, it's helpful that the IRS provided this, that limitations or penalties, if you will, that are based solely on meeting expense targets will not be treated as a risk of sharing of net loss. Another factor, which is sort of along the same lines, has to do with risk of loss of the managed property. So when we're talking about net loss, again, it's an income and expense type analysis. Here, we're looking at loss of the managed property, that is physical loss, whether it's due to casualty or other factors. This factor probably is not one that's going to be of much concern for short-term contracts, particularly like hospital contracts that we're used to seeing, and likely has more application in areas like utility properties, public utility properties, that is, and the management of those under long-term contracts. Again, the IRS provides some helpful further guidance here. One is providing that the qualified user does not fail to meet the requirements as a result of insuring, which is a good thing. And furthermore, the risk of loss factor is not violated if the contract imposes penalties on the service provider for failing to observe provisions in the contract concerning operations of the facility, even if those are sort of safety related. For example, if a contract requires a service provider to meet certain standards, and those standards are designed, say, to lessen or prevent the risk of fire, and the service provider fails to observe those, and as a result there's a devastating fire, it's okay to have a provision in the contract that the provider would be penalized for that. And, in a larger sense, that could be viewed as bearing some risk of loss. So again, it's a helpful.
Right. Mark, if I could just highlight a few points here. I do think that these two rules relating to risk of loss are basically based on the federal income tax law, that a service provider begins to look a lot more like a co-venturer or an owner if the service provider is sharing the risk of loss from the managed facility. And there's a substantial body of case law discussing what risk of loss is, and these particular requirements are not particularly well fleshed out in this revenue procedure. So I think in interpreting what this means exactly, a lot of lawyers are going to be looking at the case law for what a risk of loss really is that would cause a service contract to be characterized as something other than just a service contract, like a partnership or joint venture with the service provider. And I totally agree that this provision may be particularly important for longer-term infrastructure contracts, because the whole idea of a lot of public-private partnerships is indeed to put some risk on the service provider. And there are going to be many questions in the infrastructure area about just how much risk can actually be put on the service provider and still be consistent with this principle. And I totally agree that this one does appear to be much more of a real factor for longer-term infrastructure contracts. It's unlikely to be much of a factor with shorter-term contracts that, for example, we often deal with in the 501c3 area. So this is another example of a set of rules that's spanning across a large number of different types of contracts and projects, and some of these factors may be particularly relevant to some, and some may be relevant to others, and we're going to have to be sorting that out. If I could just move on to another new requirement, the so-called no inconsistent tax position, and that is this new revenue procedure says that to be within the safe harbor, your service contract has to contain particular express agreements that the service provider will not take any tax position that it's other than a service provider. That is, it can't take a tax position that it's really the owner of the managed property, or it's a lessee of the managed property. And again, this is a provision that makes a lot of sense for longer-term infrastructure contracts where there really might be more of a question of whether the service provider is in substance the owner of the managed property or a lessee of the managed property as compared to a short-term contract. Nonetheless, because we have this one-size-fits-all approach, literally to be within the safe harbor, every service contract, for example, every physician contract that we want to treat as within the safe harbor, has to contain these magic words. So one question is it a good idea now to include these magic words in all service contracts, regardless of term? And my view is, why not? Because to live with this revenue procedure going forward, that will be one of the requirements that's met, and at least it will create the basis for not having to worry about whether particular contracts meet this requirement. As we mentioned, the existing 9713 talks about an 80% rule, and this rule is that the term of the contract, for a term having 10 years or longer, the term of the contract can't be greater than 80% of the reasonably expected useful life of the financed property. And the basic idea is that the service provider doesn't have use of the financed property for its entire useful life, because then it begins to look more like an owner or a lessee. Previously, this 80% rule just referred to contracts having a term of 10 years or more. Now it applies to all contracts. And you might say, well, that's overkill to have that requirement, even for shorter-term contracts. But again, it's one size fits all. So literally, for shorter-term contracts, we still have to attend to this requirement. And I will say that the 80% requirement not only is expanded to apply to shorter-term contracts, but it's also somewhat reframed. And whether that's significant or not, we'll have to see. For example, the new safe harbor refers to the weighted average reasonably expected life of the managed property as compared to the financed property. That may indicate some flexibility in how this is interpreted. Again, it's just a factor we'll need to consider. We may be able to deal with it in other ways. My personal view is that one factor that's helpful for this 80% rule is having this magic language in the contract that says that the service provider agrees that it isn't the owner, that it isn't a lessee, that it won't take any tax position, that it's one of those bad types of arrangements. And that may be helpful in dealing with this 80% rule, to have that particular express agreement for how the service provider is treating the management contract for its own tax purposes.
Hey, Mike, do you want to comment somewhat? I mean, it seems, my sense is that for short-term contracts anyway, this 80% of economic life rule could be pretty burdensome. You know, when you think about a typical physician contract in a hospital, and looking at, trying to define what the managed property is, and determining useful life. It just seems like involving a lot of uncertainty, and to really do it right, probably a great deal of work. Any sense of how to approach this as a practical matter?
Well, I think that's one reason the IRS extended the transition period, because many in the industry, including me, called up the IRS and Treasury, and we said, look, this revenue procedure is great for longer-term infrastructure contracts. It makes a lot of sense. It creates more flexibility. But the fact that you have all the same requirements for a 2-year contract as a 30-year contract means that the shorter-term contracts, literally to make this safe harbor, have all these new requirements they never had before. And if the real idea is, how much the issuer or borrower has control over the property, the term of the contract is indeed a factor that's really important. I mean, an issuer has a lot more control over its property if you only have a 2-year contract with a service provider than a 20 or 30-year contract. But the safe harbor isn't written in that way, and I think that's the fundamental flaw. So we're going to be wrestling with this, particularly, how much flexibility do we have? Will the IRS loosen up on this? Will they, let us rely on 9713 indefinitely? That's unclear. So it is literally at least a compliance hassle to be worrying about this standard for shorter-term contracts, or really it hasn't been a big concern on the radar screen for very short-term contracts. I just wanted to move on to another requirement. This is actually the same requirement that's in 9713, no circumstances substantially limiting the exercise of rights, and that is basically that the service provider can't have a relationship with the issuer or borrower that would indicate that the issuer or borrower can't terminate the contract or control the contract. Is there undue influence over what is called the qualified user, meaning the exempt organization or the governmental unit, by the service provider? And the basic rule is there any role or relationship that the service provider has that substantially limits the qualified user's ability to exercise its rights? And then within that, there's still framed, this is a safe harbor within the safe harbor. They say as a safe harbor you can meet that requirement if basically the service provider doesn't have more than 20% control over the governing board of the issuer or the exempt organization, and that there's not overlapping chief executives, and the chief executives aren't on the board of the qualified user and so forth. I will say that actually this requirement is somewhat more strict than the existing safe harbor, but it's essentially the same. So I don't see this as a big problem going forward, although I note that this requirement is carried forward, but it's slightly reframed. I do want to get to just briefly talk about, there's the rule for functionally related and subordinate use, and basically this is a helpful rule that says, for example, uses of storage areas to store equipment, perform activities, does not result in private business use if the contract is otherwise compliant. That's a favorable rule, and that the margins will be helpful. There is an important question of management contracts that are leases in substance. The regulations actually expressly say that a management contract that could be recharacterized as a lease for federal income tax purposes is bad use, and there's been a long-standing question of that. The regulations expressly list 2 factors for whether a management contract can be a lease. They talk about the degree of control over the property that's exercised by the service provider and whether the service provider bears risk of loss. The revenue procedure, interestingly, references these requirements in the regulation, but it's not actually addressing whether a management contract is a safe harbor or not. When you read it technically, it doesn't say, if you meet all these requirements in this safe harbor, you won't be a lease. Our view generally is that because the factors, these new factors in the revenue procedure are similar to the factors that distinguishes a management contract from a lease, generally you shouldn't have to be worried about whether a management contract could be recharacterized as a lease if you meet all these factors, like the control factors and the risk of loss factors. However, the analysis for contracts that don't exactly meet the safe harbor will still need to wrestle with this question. And indeed, the question may be made harder because now the IRS has particularly focused on these control factors and other factors as being an important element to consider whether a management contract is private use. So this lease issue probably is made more important by this revenue procedure than before. There's a second safe harbor we just wanted to briefly discuss. This is, I think, will be important for certain infrastructure contracts mostly, and for eligible, so-called eligible expense reimbursement arrangements, where the only reimbursement, the only compensation consists of reimbursement of actual direct expenses paid by the service provider to unrelated parties and reasonable related administrative overhead expenses of the service provider. This is an expansion of an exception set forth in the regulations, and I think mostly will be applied only in special circumstances, but it is important to note that there is this somewhat expanded second safe harbor in the new revenue procedure. We wanted to spend a little bit of time talking about just dealing with this new revenue procedure. And in general, as I indicated, it sets forth fewer bright lines than the old revenue procedure 9713 standards, and we think will likely require more interpretation by issuers, borrowers, and counsel. It presents this entirely new principles-based framework that will likely raise new interpretive questions. A consideration of case law may be more important than considering some of these questions than it has been before. There may be more need than under the old revenue procedure to adopt positions that don't exactly meet all of the safe harbor requirements, but still do not result in private business use. And I think particularly this is going to be an important consideration for shorter-term contracts. In general, it's much more flexible for longer-term contracts. The term permitted is longer. There's no more constraints on fixed fee arrangements, but it creates practical problems for shorter-term contracts. The one-size-fits-all requirement creates some problems for different types of contracts. So what does this mean? For example, tax covenants in bond documents now, many bond documents expressly refer to 9713. Compliance with 9713. Clearly, I think in most cases that'll need to be interpreted in light of Revenue Procedure 2016-44. The Revenue Procedure 6, it actually will be superseding Revenue Procedure 9713. And, one best practice to consider, maybe now more so than ever, may be to avoid tax covenants in bond documents that require strict compliance with the management contract safe harbors, particularly because this new revenue procedure has fewer bright lines and may require more interpretation. Indeed, over the years, we've seen many bond documents that say every contract has to comply with 9713 unless you get a formal opinion. Well, that whole framework, I think, needs to be reconsidered. Maybe that was never a good idea. We have always tried to avoid such strict and inflexible bond documents, but maybe it's more important than ever to think about crafting bond documents that contemplate this more flexible, principles-based arrangement where we may have more contracts that don't exactly fit within these safe harbors, but the industry will get comfortable with. We'd also note that, because this new revenue procedure may cause tax compliance questions for certain types of management contracts, strategies for private business use compliance may be more important. In particular, we just wanted to note that the private business use allocation and accounting regulations published in 2015 provide very favorable rules for mixed-use projects and maybe even more important for tax planning. That is, there's very favorable rules for allocating so-called equity contributions, non-tax exempt bond proceeds to a project, and basically having the private business use allocated to or soaked up by the equity contribution. And at least for a transition period, it may be even more important to consider tax planning taking into account that rule. And we'd also note that in some cases, issuers and borrowers may be to reconsider whether management contracts that have previously been treated as private business use of outstanding bonds can now be treated as resulting in qualified use. Now, this often comes up in the context of refundings, but it could also come up in context of how much extra private business use do you have that you might have thought was used up by some non-compliant contracts. Now, before going any further, I just wanted to give everyone the CLE code, and the code is PPTN4. That's PPTN4. P is in practical, P is in practical, T is in tiger, N as in nice, 4. So that's the code, and we know we've put a CLE slide into the deck, and you'll have to enter that code in the deck again. The code is PPTN4. P is in practical, P is in practical, T is in tiger, N is in nice, 4. Okay, so getting ready for the sunset, what to do before August 18th, 2017. When this first came out and had basically the sunset date of February 18th, 2017, we thought, well, that's really less than 6 months from now, that the holidays are going to be happening. That's really not much time to respond to this revenue procedure, given that, we perceive it does create some new issues and problems. And, I think it's pretty clear that the IRS has acknowledged that it is going to create a lot of new questions and problems, and that's why they extended it to August 18th. So, how promptly issuers and borrowers are going to need to take actions to respond to it, I think it's worthwhile thinking right now about how to respond to it and taking certain actions. For example, putting these magic words in all service provider contracts. But what approaches can be taken? And one is, if it's perceived that these new requirements will create problems for certain types of contracts, they'll be grandfathered if they're entered into before August 18th, 2017, and we'll be able to apply the old 9713 safe harbors or the new safe harbors as we choose. The actual effective date says, if you have an extension or renewal that's pursuant to a legally enforceable option in the contract, the contract can be extended even after August 18, 2017. So one conceivable approach would be to amend existing contracts to put in renewal options that would enable them to be grandfathered. And, I will say that the IRS had the view, I think, that this new revenue procedure would create simplification because there'd be one safe harbor for contracts with all terms. You wouldn't have the complexity of dealing with 9713 that talked about different safe harbors for contracts with different terms. But at least for a long period of time, we're actually going to be dealing with two safe harbors in the industry. Because for a long period of time, there's going to be contracts that are grandfathered under 9713 and contracts that are not grandfathered under 9713. So 9713 is going to have a long tail regardless of how the IRS deals with it. So issuers and borrowers might need to adopt procedures for flagging which contracts are grandfathered under 9713 and which aren't. And I will say also that having a year gives us more opportunities to hear what the IRS and Treasury say about interpretation of this new framework and how strictly they intend it to be interpreted. Maybe they'll make public statements that will make the industry comfortable that we can go outside the literal safe harbors in many instances. Maybe there'll be a number of private letter ruling requests where the IRS will consider and release interpretations for different types of contracts that are outside the safe harbor before August 18th. Having a year period leaves more opportunity for that. So there is a question about, do we respond to this right away or do we let it play out for several months to see what the IRS says about it, whether they're entertaining any further guidance and so forth. I think it's important at least to start thinking about responding to it now, but maybe not revising all procedures until we see how it plays out over the next several months. So, we have some opportunity to consider questions. And one is, so undue control does undue control go to compensation? Could you have a hospital having a contract with a very lucrative physician group? What about economic control? Do you anticipate undue control will become a representation in new contracts? And no, I think the standard for no relationship with the qualified user that prevents exercise of the contract, I don't think that's changed. And in many cases, there are many contracts. This is one case where it's often facts and circumstances just to be comfortable that the service provider hasn't itself doesn't have influence over the government or exempt organization that's affected the terms of the contracts. I will say that all of these rules play out somewhat differently for local governments and for 501c3 organizations. After all, 501c3 organizations are subject to a set of rules, including private benefit and private inurement, that overlay these rules. And indeed, generally speaking, it may be more difficult for 501c3 organizations to have very long-term management contracts because they need to be concerned about whether the contract is reasonable value or fair value for private benefit purposes. And that's another reason why the longer-term contract provisions may be more favorable for long-term governmental contracts, for governmental infrastructure, and less useful for 501c3 organizations. There's another question, how will this affect reporting on private business use to the service? The determination of private business use could be changed. There could be some contracts that have previously been reported in the Form 990 Schedule K, for example, as private business use that might not be private business use. I would doubt that many exempt organizations are going to amend their Form 990s, but you may be able to take positions that there's less private business use related to a bond issue than was previously thought. I believe we're out of time, so I'd like to thank Dana and Mark for joining me in this conference, and particularly all of our attendees. Just a reminder that at the end of our PowerPoint here, we have a survey that will automatically pop up. So please consider responding to the survey. Mark and Dana and I are certainly available to respond to any questions you may have, and we encourage you, any of you, to give us a call. And again, we thank you very much for participating. This concludes our webinar. Thanks again.
Thank you.